Yo, welcome to the docket presented by Defense Diaries. I am your host, Bob Mata, and I am joined by my beautiful and brilliant co-host. I would definitely categorize you as attorney extraordinaire, badass bitch, all those things. Baddest defense attorney I know. Ali Mata, what's up, girl?
Hey, babe. Hi, all.
All right. So we decided to do this last second because I have been super pumped about what's coming up tomorrow in the Karen Reed trial and what's anticipated, what we all believe is supposed to be going down is the Commonwealth calling its witness Brian Higgins. And Brian Higgins is, of course, one of the party goers that was in the house at 34 Fairview on the night in question. And he's one of those guys that we really don't know much about. Like there's
We
not
do
much.
know that he sent that he and Karen Reed were exchanging flirtatious texts. They had like a little peck at some sort of something at his house. He sent a text after she at the bar. He didn't communicate with John at all, like didn't say goodbye when they were leaving. And then he sent a text to Karen. Are you hearing me echo?
No, that was me.
Okay. He sent a text to Karen. Well, and we also know that his car was at some point parked in the same area where
You were jumping way
allegedly.
ahead. I was just
I'm
talking
telling
about
you all the things we know. No.
I was just talking about his background, bro.
Oh, he's an ATF
Like
agent.
you're jumping into your like you're
He's an
giving away
ATF agent with an
Yeah.
office in the Canton Police Department.
Right. That was
And he's
basically
good
all we
friends with
know.
Brian Albert.
And now you've given away the whole thing. That's our live. Take care, everybody.
Bye. Night.
I mean, that's how you want to do them typically, pretty quick. In and out burger. All right. So yeah, that like Ali kind of jumped ahead. What we'd like to do is we want to address the elephant in the room with respect to the third party culprit defense. There's a lot of noise out there in the Twitter sphere, the YouTube world, about kind of what it is, what it means, what the defense needs to establish during the state's case in chief through cross-examination in order to kind of be able to move forward with that. So we thought a little bit of a primer on that would be helpful. We also are going to take a look at the actual rule of evidence from Massachusetts with regard to third-party evidence. We think that that would be helpful. We also want to take a bit of a look, and Ali thought that we might have actually covered on a live the hearing from the day of hearings, the day where they had 30 hearings on the docket, which was just preceding the trial. And one of those hearings was obviously the third-party culprit hearing. Lally was arguing that the defense had not given them any notice about the third-party culprit defense coming, which was obviously absurd. I mean, everybody who knows anything about this case knew that it was coming. So that was a very disingenuous argument, I thought, by Adam Lally. But we thought that we would revisit that hearing, hear the arguments. It's not overly long. It's probably about 30 minutes. Allison will probably make me fast forward through some of it. It's pretty interesting, though. It's pretty interesting, and it's a great primer because there's a whole bunch of shit.
No, but you could play it at 1.25 if it's not too quick already.
Yeah, I mean, Lally, we could definitely play at 1.25. We could probably play him at
1.5.
And it would probably sound like normal speed. Yanetti's not like a speedy talker either. Like Alan Jackson can kind of go. He's like a West Coast dude, you know. He's like Yannetti's got that. He's like a Mass guy. He's like a Boston guy. So he's a little more deliberate in his delivery. And then we'll kind of take some questions. If you guys have any questions about what's going on, we want to try to understand tomorrow because this guy is one of their guys. All right. Like out of the people that they kind of named in that hearing is third party culprits. It's Brian Higgins, Colin Albert, and of course, Brian Albert Sr.
So I do want to just interrupt real quick to let everybody know, at least I, and I'm pretty sure Bob feels the same way, feel extremely confident in telling you that these medical records have nothing to do with Brian not testifying, some sort of medical excuse to get him out of testifying. That is not what is happening.
Yeah, we don't think so. I mean, like, you can't get a doctor's note and not come to court. That's not a thing.
It would be something like,
Like, unless you're
so and
dying.
so's sick and we gotta call him later, or we might have to call him during the state's case, the defense's case in chief, or we have to delay trial for a day. But I don't think that that's what the medical records are. My guess, my wishful thinking guess is, oh, maybe he had some medical treatment for injuries and this is exculpatory evidence that they're having to turn over. But it could very well be that he went to the doctor within days of this and he had 0 injuries, or it could be something that we can't even think of right now.
Right. It's hard to know. It's hard to speculate. The same can be said for all 3 things that were turned over very late. We're third week of trial. We had 3 discovery, disclosures that came out in terms of there was a CV of a doctor, there was enhanced dashboard cam from Goody's Cruiser, and then this 5-page medical report regarding Brian Higgins. So obviously it causes us all to start speculating, and it makes our minds wander, and we're wondering what the hell it could be. Could it be some big deal? Is it much ado about nothing? I tend to agree that, like in Allie, like you had made a tweet earlier today, that if it in fact is inculpatory because of well, why don't you just go ahead and tell the people what you tweeted today?
Yeah. So my position is that if it's inculpatory, meaning it incriminates uh, Karen in some way, such as enhancing the video to see even better that you cannot see a body over there, or enhancing it to see her light is more broken, um, or enhancing it to overhear words that she spoke, because that would be extremely prejudicial to the defense. They didn't have it before. They've presented their entire defense based on the lack of that evidence. But as I also said, in regards to that tweet, I'm not the judge, so it really doesn't matter what I think. But if it's exculpatory in nature, then it should definitely get in. That's a completely different beast. If it tends to point to somebody else, or is helpful to the defense in some way, then they have to turn it over, and it would definitely, there should be no reason why it wouldn't come in.
Right. Yeah. And we just don't know what it is, like we'll find out maybe. Judge Bev has a tendency to kind of have these sidebars, so we can't hear some of these what would be very interesting arguments. But
Or
either
she
way,
addresses them before she turns the cameras on.
right, exactly. It's one or the other. Typically, I mean, sometimes she'll have argument on the record, but sometimes she doesn't. So let's pull up and welcome everybody. I always forget to say welcome. Welcome to fam. Welcome to newbies who we hope become fam. Again, I'm Bob Mata. I am a criminal defense attorney. This is Allie Mata, my wife, who is also a criminal defense attorney, both of 20 plus years. I have retired from practicing, I hope. And Allie, we're trying to get her retired in the near future because we want to be happy. So, and being a defense attorney is a very, very tough gig. And I say it all the time. I don't know if there's a tougher job out there, to be honest with you. We get a lot of hate. So it's like you develop a thin, very thick skin over the years of practicing criminal defense law because people don't understand what we do, and I'm not going to go into that diatribe, but it's the truth. So let's first deal with the actual third party evidence rule pursuant to Massachusetts law.
And when it's done, I want to explain the difference between that and the Bowden defense.
Okay. All right. So it's Mass Rule of Evidence 1105. And I will do what I always do. I will read it to you. So section 1105, third party culprit evidence. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has a substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote in time or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charged and a third party, or between the crime charged and another crime that could not have been committed by the defendant. So
So
there's
let's just start with that. Where we this that last sentence Bob read, if the evidence is otherwise inadmissible. Now, different states have different rules. So in Massachusetts, you don't have to prove this connection unless you're trying to get in something otherwise inadmissible, which I I'm assuming most of this would be hearsay. So, for example, I read a case, and I can't think of the name right now, but in preparation for this, where the situation was that the police said over the scanner the description that that witnesses were giving to them. They, for whatever reason, didn't know what officers said the words, and they didn't know who provided the information to the officers. So the court found it to be hearsay. So in order for, and hearsay is admissible for third party culprit as third party culprit evidence, but that is so long as they can provide that substantial connecting links. So that's what that is speaking to. Otherwise, it is seemingly, and there's some uh it seems to be defense sided, that it's supposed to default to allow this evidence in. This is something that the courts think should get in. Um, and relevance is a very easy burden to meet, although they did add a substantial probative value, where typically it's just that it's more probative than prejudicial. So but definitely the case law suggests it should default to being allowed in, and that the defendant should get the benefit um, of that evidence when it's a close call. But then you have this whole other level when you're looking to get in things like hearsay and things of that nature.
all right. So in terms of let's apply it to this case. Okay. So we know that, and we're going to jump into the hearing, but we know that there's a third party culprit, or three in this case. The defense has put forth this concept that something happened inside of that house, that John O'Keefe was either beaten in the house and dragged out still alive, or beaten to death in the house and dragged out deceased and left in the front yard. And they've, at this point, they've put out who they're asserting that it was and alleging that it was. Again, it's Brian Higgins, Brian Albert, and Colin Albert, one or all of the three. So in terms of them meeting their burden,
Well, I would say
in terms of showing Judge Bev what she needs to see in order to allow them to move forward, what do you think that they need to be showing during cross? Because remember, one of her rulings is she would not allow for the defense to even mention the third party culprit defense at all during the opening statement. Okay,
right.
now
So she said, after they made their entire argument, she said that she'd be well within her rights to exclude that evidence, but she wasn't going to do that. She was going to give them the opportunity during trial to um to present it, to round it out with reliable, credible, admissible evidence.
Okay.
So when you
Right,
talk
right.
about the
So, but like, what
motive,
I want you to specifically talk about what they need to be showing. Like, what do they need to draw out from these witnesses to pass the threshold where it's not just pure speculation?
well, that's what I was starting to say. When you look at motive, now, if I recall correctly, and it might be in what we're about to hear today, I think Yannetti, when he started talking about Higgins and the text message and the flirtation and the kiss, that I think he may have said the words like, "We're not saying that that's motive to kill, but it's definitely bias, and we can explore that." So I don't know as far as motive, is that are they going to end up defaulting to that and saying that the motive could have been a fight that, and then you get to speculation. Did he see the text? Did he not see the text? Did they talk about this before? Did they not? That I think is very speculative. Did he even come into the house? Is that
Well,
speculative as far as opportunity?
right, but the challenge in this case is the fact that if he did go into the house, we know that none of these folks that were in the house are admitting to anything. So how do you prove a negative? You know what I mean? Like they're like the case against Karen Reed in and of itself is all circumstantial. Not one of those people saw her hit John O'Keefe. It's the same case that they have against Karen Reed that the defense essentially has against the third party culprits in that house. They're
I
both
would agree, even
circumstantial cases.
even more so for Brian Higgins because his car was in that area. He actually has a snowplow at the end of it that potentially could have made those injuries to his arm. But as far as what it seems the defense is trying to put together, which is intent by showing that the text was to draw. I don't know how the text to Karen was to prompt, you know, Brian I mean, John to come into the house. But, the question becomes so you've got motive, intent, opportunity. So, you know, is the motive just that he had a thing for his girlfriend? Is the motive because you have to think about what we talked about when the judge allowed the sister of Marietta to say, I spoke to her, like there was I can't remember what it was, but it was one of the conversation in the pool that she had with John, where she asks John, "Are you happy?" And I'm getting frustrated and angry, like, wait a minute, this evidence should not be allowed. It's not showing uh Karen's state of mind or John's state of mind. And the judge had given the instruction that unless you believe that Karen was aware of this information, then you can't consider it because if she doesn't know that, then it can't be used for intent. So saying that somehow John figured out that there was a kiss between Brian and Karen, I don't know. Is that speculative? Is it not?
I mean,
But
no more
I agree with
speculative
what you're.
than them using this remote Aruba, blow up that happens 3 weeks prior to the 28th, 29th of January, wherein Karen allegedly has it out with, Etta Sullivan. And, Karen has some misapprehension or she has a misunderstanding of the relationship between John and his goddaughter and assumes that, oh, this young girl's macking on my dude, fuck you. And then we of course have her Etta saying fuck you back, and it's like it's one of those things where you're like, look, um is that too remote in time? Like, are we supposed to believe that that is the impetus to murder, that has Karen on the ropes mentally? And even if Karen is on the ropes mentally about the longevity or possible ending of the relationship with John, I've seen no evidence whatsoever that turns Karen into a murderous person. You know what I mean? Like it's
Agreed.
a huge leap. Like
It's a
I've
huge
seen
leap.
no evidence whatsoever that Karen has a history of being incredibly violent when it comes to men breaking up with her. That there's this history of her, being a violent person in general. Like there's just no indication of that, and this like this drunken rage thing. Like they haven't proven up to this point, and they've had the opportunity through the bartender at the waterfall who's already testified to talk about how much she may have remembered serving Karen. She could have provided and gotten into evidence by laying the foundation and authenticating a receipt from the waterfall as to how much booze was purchased by the party in general, and then saying, okay, well, there were 25 shots of vodka that were purchased total if they all had one bill. And we know that Karen was drinking vodka. We know that Matt McCabe was drinking vodka and Crystal Light because he was so ashamed of it. And, and do the math from there. But we've had really no evidence whatsoever thus far as to how much she has consumed. And, I've had a doctor, and I read it on Jay and I's live, which, by the way, if you guys don't know, Jay, the Shaming of Jay, and I have been live streaming this trial from the very beginning, and we're going to go all the way to the very end. Every day we flip flop our channels. Tomorrow is my channel, so we start 15 minutes beforehand. If you're watching other places, maybe come peep us, check us out. You might like our coverage. Jay's hilarious. I know a little bit about the law. I kind of think I'm funny. I don't know. It's questionable. But we think that we put out some pretty good content. Come and check us out throughout the trial. Bounce around. Come and see what's up. But as far as I don't know. It's a fascinating case in a lot of different ways. It really is. All right. So
I
know,
want
I
you
know.
to read the first paragraph under the rule, because it speaks to a lot of what we were saying, and speaks to the
You want me to
um
pull the rule back up here?
yeah.
Okay. All right. I'll pull
And
it back
while
up.
you're doing that, the other thing that we also have in our favor is that consciousness of guilt evidence can be offered as assuming third party culprit evidence is allowed. The consciousness of guilt evidence would get in. That would include him destroying his phone and any number of other things that he did that shows consciousness of guilt.
Right, which we will definitely get to, because like when we get to that hearing, Yannetti breaks it down. Like Judge Bev says, I need to hear it. Like I like we've been going for as long as we've been going pre-trial. I've heard you threatening about employing the third party culprit, but I don't know anything about what you have in terms of evidence to try to push that forward, to move that needle. So Yannetti goes into a lot of the facts, and it's an excellent primer leading into tomorrow to kind of figure out, all right, look, this is what we got. This is what this is what we're going to be looking at on the cross. This is in Jackson's doing the cross tomorrow. And and he's quoted as saying to expect fireworks. So it's like, is this like, I was very excited about Jen McCabe's testimony. That did not disappoint. I thought it was a heavyweight bout. I thought that Jen McCabe really held her own. I think that she lied about certain things. That's just my feeling on it. I think that she was dishonest about things. I think that she was evasive about things. And I don't know why, but at the same time, she did not back down. Like she went toe to toe with Jackson. Like it was a very combative cross examination, and it was. Shut that door, please. I'm on a live, and don't come back in. Sorry, our daughter's sick. She's a little under the weather. I love you.
So I barked at her.
Well, she left the door open
I mean,
into
she was
the inner
supposed to be. I
sanctum.
thought she was in bed too.
I know.
Maybe she went to go to the bathroom.
No,
Was.
leave that door open. I need that. Just leave everything the way it was when you came in, love. All right, sorry. We got a family. What are you gonna do? All right, so like I can't even remember what I was talking about because she left the bathroom door open. All
You
right, so what
were
was I
gonna
saying?
read, yeah, you were gonna
No,
read
I
the
was saying whatever. All right, so third party culprit evidence. I'm going to read this paragraph down here at the bottom. Third
wait,
party culprit evidence. It's evidence that someone else committed the crime charged, or had the motive, intent, and opportunity to do so. Is a time honored method of defending against a criminal charge, and that comes from Commonwealth v. Rosa. A defendant possesses a fundamental due process right. Hold on, I got to switch this thing over to scroll mode.
I don't know how yours defaults. Mine's always on scroll mode.
No, I always got to put enable scrolling. It's super annoying. A defendant possesses a fundamental due process right to present such evidence, Commonwealth v. Jewett, and doubts about admissibility should be resolved in the defendant's favor, and that's Commonwealth v. Conkey. Because the issue implicates constitutional rights, appellate courts review the decision to exclude third-party culprit evidence independently rather than for abuse of discretion. Explain what that means.
Okay, so and I'll just give this example now. So the case that I spoke of earlier that I was giving as the example where they wanted to get in the fact that police had called in a description of someone who did not look like the defendant, and they did not let it in as third um third party culprit evidence because they couldn't make that connection, that second part of the rule. And in that case, they look for um they look for whether it was just an error rather than an abuse of discretion, meaning in like if it's just an error, you don't have to go as far as showing it was an abuse of discretion, which I think is typically defined as like a trying to think of like the exact words, but it's just not a rational reason that the judge sort of just did it for lack of a better word, like willy-nilly. But if you don't have to use abuse of discretion, it's just was there an error and were they prejudiced by the error? So the finding of an error is a lower standard than a finding of an abuse of discretion because that has to show the judge like really did it willy-nilly.
Right. Well, and the concept being that judges do have a lot of discretion. They are given a lot of leeway in terms of their rulings on evidentiary issues. All right. So the appellate courts aren't like lording over them, nitpicking everything, like every single thing that they do. So like in order for an appellate court to reach that level of, all right, this is something that was in the judge's discretion, within the judge's discretion to decide on, but just went way overboard. And at that point, abused their discretion, or it was an issue that they don't have discretion on, that there's a hard line rule, and that inhaler is downstairs on the
All
arm.
right, so because this involves a constitutional right, that's why they're saying they don't use the abuse of discretion standard, but they use the erroneous standard. So,
All right, but do you
turning
think that
back
I
to
was
that, hold on. Turning back to that other example that I was giving where there was the phone call, there's two things. There's also, and you guys have probably heard them use the word Bowden evidence, or I mean Bowden defense. That is dealing with when you're showing that the police did an inadequate investigation. And if they would have conducted a full investigation, there could have been other evidence bearing on the guilt or innocence of the defendant. So in that specific case, the court found that it was an error under the so it's hearsay what was said over what the police said over the radio that they got from witnesses. They call it layered hearsay in Massachusetts, meaning hearsay upon hearsay. A lot of times we call it just double hearsay, but in any event, hearsay always involves something being offered for the truth of the matter asserted. So, in the situation of a third party culprit, you are offering those other descriptions as truthful things somebody said that described someone that didn't look like the defendant. Now, when you flip that and you talk about Bowden, you're talking about an inadequate investigation. So it doesn't matter if what the people said was true. You're not putting in the statement to prove witnesses actually provided another description and asking the jury to accept that description as substantive evidence, as actual evidence of what the person described them as. Instead, you're offering it to prove the police did not follow up on a lead. So in that case, it's allowed in, even though otherwise it would be hearsay. Also, in that case, they don't find that's a rises to a constitutional right, such as it is when you're putting on third party evidence. So it went to a abuse of discretion standard. And when they got to actually they did find that it was an error. When they got to prejudicial, they said there was no prejudice because there was a lot of other evidence against this guy. And even though he didn't look like that description, he met the description that everybody gave for the actual eyewitnesses in person gave for the height, and people identified him. So it's two different ways to get in the same evidence. So the defense could get in all the things that they didn't follow up on and explain to the jury how that could have led to evidence that was exculpatory and proved her innocence. So it also creates like a loophole for them to get that evidence in another way, but they don't want to rely on that.
Okay. So I'm going to finish reading this thing. So rather than for abuse of discretion and the erroneous exclusion of such evidence upon proper objection requires reversal unless harmless beyond a reasonable doubt. And that's Conkey. So then in parentheticals, the trial judge has discretion to rule in advance of trial that the defendant has not made or had not made an adequate showing that three potential culprits were connected to the crime, and that the defendant should provide advance warning to the court before offering evidence or argument at trial of a third party culprit, which was basically what Lally was arguing, that he didn't get that advanced warning. Bev ultimately, she didn't entertain that argument.
Well, basically, she did rule that. She says, before you offer it, we need to talk about it again to see if I found that you've kind of gotten there. But now,
ultimately, she ended up she actually ruled that they can try to bring it in through cross-examination. So she didn't limit it, at least in the sense that she was going to allow them to attack it, like they were
the
allowing
opportunity
them
to develop it.
Right, like through the cross examinations. Now, whether or not she's going to allow them to argue it is what's yet to be determined. Like ultimately, she's going to have to find that they've been able to provide sufficient connective tissue to these people and the crime, so that it doesn't come off as just mere speculation. So which is why tomorrow was such a huge day. I mean, Brian Higgins, I think in the eyes of Yannetti and Jackson, is probably the primary culprit, right? I think that they think that he's the guy, which goes really back to what you were talking about. We know that these text messages exist between Karen and Brian Higgins. Like they I don't know if it was her flirting with him. I don't know if it was him flirting with her. I don't know if it was mutual, but there was a little something going on through texting. And, I think that obviously Yannetti and Jackson are, of course, talking to Karen Reed. Karen Reed, who I do not believe under any circumstances is going to be testifying in this trial. I'm going to call that right here and right now. Can't see that happening. But she's talking to them. She is a huge well of information, a huge source of information. She's going to be candid with those guys in terms of whatever may have been going on or not been going on with Higgins. Now, obviously, she's got John O'Keefe's family sitting in the courtroom. She's obviously, huh?
On her side?
I don't know.
Sorry.
To me, that's irrelevant. That has nothing to do with it. I'm talking about sparing
I hear
their
you.
fallen son's parents' feelings in terms of her saying, look, well, I've got to be honest that, this thing was going on. There was some, you know, and pretty intense texting going on between us that there may have been, whatever the case may be. She's got to make that determination, if she's going to save her own hide. And in order to do that, she's got to be completely candid about what was going on, if anything, between her and Brian Higgins, right? So, but my point being is that she's talking to her attorneys about it. They
Right.
know
And
anything that might not even be in text. They know. You
yeah,
know what I'm saying? So, like, and that's what they're filtering everything through in terms of what she's saying that relationship was or it wasn't. So, like, when we get to this hearing, which is going to be in short order, you can tell Brian Higgins is the guy. Like, he's the guy that they think was either the impetus of it or whoever may have started this, whether it be John coming in hot into the house because he found out about it and he's coming in and something breaks out right away. I mean, who knows? Who knows if any of it went down? I mean, we're still to the point where we don't know. Like I'm so enamored by this case because it like, to me, I still, and I hear both sides. I hear the people like, are you nuts? It's clearly it's a cover up. It's a conspiracy. Are you nuts? She's clearly guilty. That's not where I'm at. That's not the dude I am. Like, I'm the guy who sits on the fence until I hear all the evidence, and no amount of bullying or name calling me an idiot is ever going to change that. I'm a defense attorney. I wait for the evidence to come in, period. End of conversation. That's all there is to it. Anybody who says anything about me ever, whether it's Delphi, Reed, I don't care. The content speaks for itself. I wait until the evidence is in, and then I decide. That's what can I have an initial reaction? Yeah, of course. Do I make a final decision and start carrying a torch and pitchfork and start screaming about somebody's guilt or innocence before the evidence? No. And none of you should be either, to be honest with you. It's a bad look because all you're going on is speculation. Until the evidence is vetted at trial, that's the only time you can make a real decision, because the rest of it is all noise. The rest of it has all been filtered through other people's bullshit. And until you see the evidence at trial, like if the Jen McCabe cross-examination wasn't like proof positive to you that you need to wait and see these people testifying and let them answer the questions that we know are coming and see how they respond. And then base on your own determinations with your own eyes and your own ears, whether or not you believe a witness when they're making certain statements. That's how you do this thing. That's how the Constitution works. That's how the Confrontation Clause of the Sixth Amendment works. You have to see it happen at trial. Everything else is bullshit. People can make I have read some of the most compelling arguments on both sides of this thing going into this trial, where I'm like, wow, yeah, that's super compelling. Karen did it. And oh man, yeah, no, this is incredibly compelling. This is obviously conspiracy. I've read all that stuff. I've seen it all. There's very compelling arguments. There's very compelling theories out there, but that's all they are until trial, until we see the evidence. Do y'all understand where I'm at? Because I just want to be clear about it, because it seems like people are very unclear about where I stand all the time. And on every single case, I'm on the fence. I'm on the fence, guy, until I hear the evidence. And then I make a decision. And then you know what? Sometimes I still don't know. That's
it
fact.
happens. It happens.
It
All right.
happens. All right. So,
All right, wait. I want to read a couple other things. So,
okay.
some more case law. So, while defendants are entitled to wide latitude in introducing third-party culprit evidence, the evidence must be relevant. That is, must have a rational tendency to prove the issue raised by the defense and cannot be too remote or speculative. So, it goes on to say, evidence of a third party's ill will or possible motive to commit the charged crime standing alone is insufficient to qualify as third-party evidence, third-party culprit evidence. The evidence must also show that the alleged third-party culprit had the intent and opportunity to commit the crime. So they give a couple of examples. One, noting that defendant was permitted to introduce evidence that alleged third-party culprit had loud argument with victim in the morning before the murder at campground where the victim's body was found. And they give another one, reversible error, to exclude evidence of alleged third-party culprit motive to commit sexual assault, where the third party was the victim's landlord, possessed the keys to her home, and had recently opened lingerie drawer in her bedroom. So there was at least there was all the things were met there. Now they rejected it. Here's some rejected the notion that the victim's status as a drug dealer and possession of weapons, together with drugs found in the victim's car and in the victim's clothing, without further specificity, provided ready-made third-party culprit defense that hypothetical rival drug dealer killed the victim. I don't think we're anywhere near that far off in this case. But another one is evidence that rival gang members lived near the shooting and were involved in a feud with the victims. Not sufficient to support third-party culprit defense where there was no evidence that they had been nearby at the time of the shooting, and only defendant and intended victims were seen holding guns. So we at least here, we do have them nearby, obviously. The question is, did he ever make it in the house? And I think personally, there's enough evidence that it's not too speculative that he made it into the house, that it's a real possibility, and it's something that should be left to the jury to decide. That's me personally on opportunity. And then the last example I want to give is one more where they said evidence that alleged third-party culprit had threatened to kill the victim more than 1 year before her murder, properly excluded where no other evidence tended to show third party had been involved in murder. So there's a couple of examples of how that this has been applied in other circumstances. Oh,
Okay.
and then they actually speak to admission to establish inadequate investigation. And it says, wow, this is perfect because this is what I was wanting to go into next. Evidence that does not qualify as third-party culprit evidence may nonetheless be admissible as Bowden evidence. That is, evidence offered to establish the inadequacy of a police investigation. And they cite Commonwealth v. Silva. They cited Bowden just before that. And there they say, explaining that information regarding a third-party culprit whose existence was known to the police, but whose potential involvement was never investigated, may be admissible under Bowden defense, even though it may not otherwise be admissible under a third-party culprit defense.
Okay, so you read it. Now explain it.
I think I gave a good example earlier of the case that we talked about. That was like a real life application where they refused to play to the jury the description, the police calling over the radio, the description provided by the witnesses saying that was hearsay, layered hearsay. But when it came to evidence that there was a inadequate investigation, they said no, that should have been played and it was an error not to play it. So if they say that the police should have, if the judge says, you know what, I think it's too speculative, this text and the issues with Brian and even the consciousness of guilt, all those things could still get in to talk about how the police failed to do any independent investigation into Brian Higgins at all, despite the fact that he destroyed his phone, or despite the fact that they had some sort of relationship and there's these other, other suspicious activity going on around this time by Brian Higgins. So it's another way that the defense could get it in. But as I said before, they don't want to resort to that because then the jury gets an instruction that that's only allowed to speak to, that they don't have to accept that evidence as true. It's not being offered for the truth. It's just being offered to show that the police didn't do an investigation. And then we all know when people hear it and they hear it, they're still going to take it into consideration. I don't know how fine of a line and how much parsing the jurors will do, or even if they'll necessarily know how to apply that kind of difference. But if it
And
gets in
that's
as
the $1,000,000 question. Like that, and Canoni's pretty good with her limiting instructions, and like she's very deliberate in terms of addressing the jury. And I feel like when she gives those limiting instructions, when she knows that something's coming up, that is going to fall with under, one of her rulings with respect to particular evidence, like she did it with the Sullivan sisters in terms of the limiting instructions, like what they were able to use that information that they were hearing from the sisters with regard to guilt or innocence as to Karen Reed. Like, so, but it's kind of a complicated theory. It really is. And in this case, because of the nature of the investigation being so shitty, which I don't care which side you're on this. If you're sitting here and objectively looking at that investigation and saying that it's not shitty, you're full of shit, because it's a terrible investigation. Every cop I know is disgusted by that investigation, starting with Joe Jackalone, even Cheryl Mac McCollum, who I think probably leans towards the side of Karen Reed's guilty, was disgusted by that investigation. I know that Emily D. Baker, who's a former prosecutor, disgusted by that investigation. We've had Joshua on a couple times, Joshua Ritter, who's worked with Alan Jackson for 6 years, worked with him in the prosecutor's office. He's disgusted by that investigation. Like, it was for shit investigation. We've been criminal defense attorneys for 20 plus years. I'm telling you, like, that is the kind of investigation we live for. And it's not just the solo cups and the shop, the shop and save bag. That's the tip of the iceberg. They didn't investigate anything at all. Like Yannetti's, the brilliance of Yannetti's cross-examination of the Sullivan girls was a masterclass in less is more. He asked 3 questions. You weren't there on the 22nd of January, right? Correct. You weren't there on the 28th going into the 29th of January, right? Correct. And the final one was, and yet, despite the fact that you weren't at either of those events where all these people were, and where John O'Keefe was the victim and Karen Reed was, yet you were interviewed on February 7th or 8th, whatever the date was, a mere 7 or 8 days later, where everybody in that house on whose lawn John O'Keefe's body was found were not interviewed for months, sometimes longer than a year. Like, that speaks volumes about that investigation and how full of shit it was. And I'm not going to get into a huge diatribe about, the shit that the McCabes and the Alberts have been taking. I do know, you and I are attorneys. We have taken an oath. We follow the law. We defend the principles of the Constitution. It's our job. We would never, ever condone anybody harassing a witness of any kind and in any way. It's illegal. It's criminal. So, notwithstanding that fact, in this case, these aren't your normal witnesses. These are people that should have been investigated and cleared. If I'm the McCabes and the Alberts, I'm fucking, and I didn't do anything. I am furious that they didn't do their investigation properly. Because had they done their investigation properly and we didn't do anything, you know what? None of this shit's going on at all.
And you're probably, if you're the spouse, infuriated with those who destroyed their phones and, friends that,
all of it,
that crunched up their SIM cards.
Because whether or not something happened in that house, it's the appearance of impropriety. It makes people think you're suspicious when you do suspicious shit. Period. Right. It's that simple. This
And
isn't
we're about
rocket
to get
science.
into this, Diana. We're about to play something and then talk. The
Yep.
federal proffer will definitely be something that we
Yeah.
discuss.
All right. So let's dive into the let's dive into this little guy first. All right. So let me stop sharing that guy. And let me get into the first little dude here. Hopefully this works. Okay. Now, I'm going to give a bit of a warning. So this stream, I noticed there was some cracking, like some crackling. So it's kind of irritating. It's not coming from us. It's coming from this. If you guys find it to be unbearable, let us know in the chat and I'll pull it.
Did you try seeing if that's law and crime, if there's someone else that has it? Like,
Yeah, but at this point, I like
TV?
edited, I cut out the bullshit. And
Oh,
like,
yeah.
this
I
is the one
forgot
we're
you
going.
did that. Right.
This is what we're going with. All right. So, let me see. Where's it at? Okay. This is the guy. All right. So I'm skipping right to, and Canoni had the conversation going back to what you were talking about just prior, with kind of this intertwined issue of the Bowden thing
Inadequate
and the
investigation
inadequate
versus third-party
investigation
culprit.
and how it's really intertwined with the third party culprit thing. So she had that conversation just prior to this. What this is that, so this is the beginning of the third party culprit hearing.
Though they're argued together, I do want you.
Can you guys hear the sound?
Also start
Yeah.
with
Oh.
the third party culprit alone, not third party culprit as it goes to Bowden, but third party culprit alone, because of all those factors that I told you. As you well know, the case law is clear that I have to consider. And if I had to do it now, and you know I can do a pretrial, right? You know that I can today, I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to weigh those factors, because right now I have zero information.
Right, I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, I'm getting to that in terms of.
Go ahead. You have your remarks.
That we're either required to give them or not.
I don't know if I can.
It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowdoin defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective. So, and as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
I'm happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss.
Is that where he just said, this is coming from the proffer?
Nope.
Okay.
At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves. But before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him. And that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the Riot Act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview. And when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, you know, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton police station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work, but then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call around the same about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Laughlin, the plow driver, first drives by the house and sees nobody at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done.
All right. So let's kick it right into. So you have any comments before we go into the second one? You're muted, I think. What a Bob move.
Right. I was just going to say that I was glad we gave everybody a primer because they understood, I would hope, most of what he was saying and why he was saying it. Like when he said, we're not trying to get in any hearsay evidence. So we don't have to take that second step and go through the connectors. And he talked about the motive. Now that I heard him say it again, he cleared it up. I don't have to prove motive because, and I'm assuming it's case law that they probably cited before, because we can use any sort of bias as motive, which when we read the other thing, like ill will alone is not enough. They also need to establish intent and opportunity that coincides with him saying that ill will can be motive. So, right. And he also touched on the consciousness of guilt and how that's important in this analysis.
Yeah. And so when we get back from the little break here, some of this consciousness of guilt stuff, like what Higgins does at the military base is next level shit, man. So let's dig right in. Oh, and when you guys see that QR code that we throw up there in the corner. If you scan that with your phone, like any other QR code, brings up all our links. I noticed on our border, my Twitter, which is a pretty big account, it's defense_diaries. That's a typo that we don't have that in there. But I think that the right link should be in the QR code. And make sure you're listening to this, the podcast. The podcast is great. We do all kinds of stuff. My dad was Gacy's lawyer, gave me all his taped interviews with Gacy. It's a pretty good season. We think it's pretty amazing. And our second season's pretty awesome too. It's different. It's serialized. And then, of course, Allie and I do the docket where we cover all the current stuff, which is what we're doing now. All right. Without further ado, let's go.
The morning of January 29th.
Oh, wait. I got to switch it out. Sorry. Just kidding.
What is this? What does that mean?
What do you mean? I cut it into 2 different videos.
No, this whatever you call it. Chat.
It's not wrong. Your report is wrong. What do you mean? What are you talking about? Like the Twitter handle is defense_diaries. I swear. Are you saying that that's wrong somewhere else?
I don't know that that's what she meant because she said the report is wrong.
Oh.
Or the report is not wrong. I don't know.
All right. Okay. So let's see. Right,
oh, your report is wrong. It's not wrong. Your report is wrong.
The person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz.
Oh, I get it.
Immediately after getting off the phone with Brian Albert,
she's so funny.
Brian Higgins drives back to 34 Fairview, where he has a meeting with just about all the witnesses in this case: Brian Albert, Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after,
everybody else got it except for us.
Sorry.
Off, which is a Saturday, he returns to the Canton Police Department, where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify to seeing Chief Kenneth Berkowitz and Brian Higgins alone with Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth? Or
Yes.
is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Butnick have all had access to it. At 5:50 p.m., that's during the missing video. Trooper Proctor, Trooper Butnick never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Butnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this incident.
Outrageous.
Do the limited extraction. He never tells Trooper Butnick or Trooper Proctor how he extracted the tests. despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone.
Okay, so there you go. During the federal proffer. So that ends any speculation on whether or not.
But he gets into what was said, so that
Yeah,
also
just want to point it out.
ends some
You know,
speculation about what might be involved in this.
Yeah, we do. I just want to point it out. Proffer was made.
The order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night. He had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe Street.
Is your plan to go through everyone, or are we just going to do?
Yeah, what are you talking? We got 15 minutes left. We're doing the whole damn thing. Dude, I cannot tell you how much I love this. How much I love this motion, how much I love this fucking hearing. I love these two lawyers. They're like, we're defense attorneys.
I just want to make
no mistake about it out there. We are defense attorneys. I love defense attorneys. I love everything that we do. I love everything that we stand for. And these two guys are shining examples of why we need defense attorneys in this world, because they're doing their work. They're doing what needs to be done.
So yeah, we're watching. We have the. Do we also have the state's response, the Commonwealth's response?
Yeah.
Okay.
Lally gets up there and, talks for 3 minutes. Basically says everything that these two guys said is bullshit, or, like typical shit. It's quick.
Just 2 doors down, we have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the get off my lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now, the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe. So I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury. And at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th, 29th. And now the DA will argue, I'm sure, at trial that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're
Goddamn right.
to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. And with regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's a nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt. And perhaps most of all, Brian Albert is a first responder. He is duty bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived. He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had
said, don't talk about the
curiosity as to what was going on in that house that night. They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. The Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. It's for those reasons that I ask you to deny the Commonwealth's motions.
Okay.
Big sigh by Darth Bev. She's got that big. All right. So before we jump into Lally's counter, do you want to explain the difference between a proffer and an immunity deal?
Yeah. So a proffer is the information that you provide, that you proffer, and you're given immunity as to that information. So it's sort of, they run hand in hand, but it's what you have immunity for is the information that you proffer. Did that explain it?
It explained it to me. Do you all feel that was a sufficient explanation? Do you guys have any further follow-up questions with respect to that explanation? All right, let us know in the...
And there's also other types of immunity. So I was explaining the way immunity works with a proffer, and it depends on the type of immunity that they agree to. In that, it's usually just that they can't use that information from the proffer against you, but often doesn't prevent them from going out and developing that same evidence, just using something else to establish the same information you provide in your proffer. And then you can just have like an immunity deal that's not tied to like a proffer. It's just tied to like, you're going to testify or you're going to do whatever, typically you'd also at some point have provided a proffer, meaning told them the information that you were going to either testify to or what they needed to know.
But a state proffer and a Fed proffer are very different beasts in terms of how the feds deal with a Fed proffer. Like he wouldn't be able to go in and take the fifth on the stand with a proffer.
There's no chance that anyone is pleading the fifth, and the state is not. I'm trying to figure out it. I didn't think about it to look it up about if the state would be bound by a proffer deal just because they gave them the information in the proffer. But in any event, what was I? Oh, there's no chance in hell that he's pleading the fifth. I mean, he'd have to give up his job. He'd lose his job if he pled the fifth. I mean,
for sure. And when Yannetti was done with this particular argument, this is exactly what popped into my mind.
Do you like apples? I got a number. How do you like them apples?
Yeah. That's the shit right there. All right.
You guys gotta clean that one up. I
that
just want to
one's
hear
solid gold.
I just want to hear, but cleaner. I want to hear, you like apples? How do you like? I don't even need that little middle part about I got her number.
What? That's the best part. That's the I got
so.
You moment. Come on.
Okay.
Any response, Mr. Lilly?
Briefly on
it. Extreme close up.
Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence.
Thank you.
I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit evidence that he has.
Wow.
He references in regard to third-party culprit, Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe's arm. Furthermore,
it's still evident. It's a factual
jury materials in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstructionist as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever. There is also a medical examiner in the federal materials who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So with regard to each of these, the other thing that I would point out is counsel of record with the Finney case. The Finney case relates to third-party culprit under the Bowden event. So it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that is summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert. Just starting with Colin Albert, because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm. With each of every single of the witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury, they testified to the exact same things in the federal grand jury. That Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just
rank speculation.
Yeah, because the cops didn't do an investigation, Pinhead.
If he's not even there at the same time
Wow.
as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's reported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things.
Most of the
or
things.
the imputations or the connotations the council wants to put behind that. Whatever he feels things were observed. So again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case, well before counsel was provided with any of those federal materials. What counsel just went through is essentially a list of rank speculation and not actual evidence. As far as the mysterious portion that's missing from the Sally port, there's a number of different, it's a motion activated camera for the most part. The other thing that I would direct the court's attention to, as it was contained within the state grand jury proceedings, is there is cruiser camera video from the Canton Police cruisers. Specifically, there is cruiser camera video from Cruiser 682. Specifically, there is cruiser camera video from Cruiser 682 at 8:22 in the morning.
There you go.
Sergeant from the Canton Police on their
Pause
own
it.
go over to One Meadows Ave, which is the residence of Mr. O'Keefe.
I think we can almost be guaranteed that possibly that's what was enhanced. The tail light that's displayed in that video. I mean, that same police cruiser is also, pulling up to the scene and doing all those things as well. But that is what one of the things I was thinking. I was like, is 682 also the one that was there for the tail light?
Yeah, it was. But when I was reading through Goody's report, at least the only one that I've seen, he doesn't even get to that portion of his narrative stops. His narrative stops after he talks about the section 12 for Karen. So I know that it is his crawler that goes over there.
Right. I mean, that's what he said.
But that goes to your tweet earlier today. They've had 2 years
to enhance
to get that enhanced. I think that if they consider it to be inculpatory, that it should be inadmissible. You had 2 fucking years to get that over to the defense, and now you're bringing it in the 3rd week of trial. Get the fuck out of here.
Now, I could see the judge, if she were to agree with that, I could see her saying, but if you put it in your case in chief, then I'm going to let them get this in.
Put what in their case in chief?
Stick with the, with the tail light wasn't broken and they did it in the Sally port.
Yeah, I could see. I mean, they'd have to be able to offer it for rebuttal, right? I mean, that would be rebuttal evidence for them. In terms of and that
would take a lot of wind out of the sails of the defense. So
I don't know, and this is just my personal opinion. I don't know why they're married to the fact that they must have gotten something back. Like I had made a short where I was saying, well, if I'm Yannetti and Jackson, there's 0% chance that I haven't engaged the services of an accident reconstruction expert to replicate Karen backing out of John's garage for that video that we've all seen, wherein it appears that she could have hit John's Chevy Traverse, in order to do 2 things. One, to verify with an expert that in fact, despite the size of the bumper, that if at that angle, the taillight could have come in to contact with the wiper, with the, because the windshield wiper on his back window, it sticks out probably 2 inches, like your typical 2-inch wiper assembly, and the second thing is, because like I have to be honest, when I look at that video slowed down and I was showing you, to me, it looks like the tail light is cracked. Like it looks like there's a piece missing. It doesn't look like the entire piece of plastic is gone, but it looks like there's a gap in the tail light. You know what I'm saying? Like, to me, I'm thinking, all right, is there a likelihood that she did hit the car? And if I can prove that damage would have occurred, because I just don't see a taillight cracking at 24 miles an hour hitting a human being with this,
And that's
polycarbonate shit that they make these taillights with.
And that's what I'm thinking I would be more focused on as the defense, is establishing that the tail light would not have broken if struck in the manner the Commonwealth presents. Because eventually they're going to have to present the actual manner that they believe that the damn car hit the body. And I think if you can put on an expert to say that compact, the way they described it, would not cause it to break, that's even better, and you just got the inference from the other.
Yeah, and Susan makes a good point. So Goody, I believe, is testified. He testified early, and they didn't bring that video, at least the enhanced version, into evidence. I think that they brought either a still photograph. I don't even know if they brought an actual video. They might have showed him pulling up.
I think I remember. Yeah, I guess it could have been a photograph, but I thought I remembered a video.
It might have been him pulling into the driveway behind the Lexus, and you cannot tell. You cannot tell from that particular video. My whole thing is, man, like they had plenty of time to enhance that. You know what I mean? Like, what are they going to recall him? I don't know if they released him or not as a witness, but I don't know. Let's hear the rest of this.
Well, the Commonwealth shouldn't be allowed to recall him, but unless they did specifically, sometimes you do say, I'm going to present this witness here and now for this, and then present him again. So I guess it is possible the state reserved the right.
Right. You're right. He might not have released. I don't know.
To do a well-being check because they had not received any information as to how the children were or if they were there being attended to. And they pull into the driveway at 8:22 in the morning, directly behind the defendant's vehicle, which is exactly where Ms. McCabe parked it when they stopped there to see if Mr. O'Keefe was there, before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle. Well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton. And then the vehicle had then been towed from Dighton back to the Camden Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Miss Reed were present at the house. So again, I think it's a stronger argument, certainly, if we're trying to bootstrap onto a Bowdoin defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature. But there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, the Commonwealth's motion to exclude it should be allowed.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that The car pinged at 5:30.
So hold on until you get to the
Wait,
microphone.
babe, pause it a second.
Car pinged at 5:36 p.m. indicate.
I was trying to read something and I think I just missed. Didn't he talk about the that the state told him that he could delete his phone or destroy his phone? Didn't Lally touch on that?
No, I mean, he didn't address it specifically. He just generically, like, that's where he said, "Oh, and everything that they said about Brian Higgins is like that was a fanciful story."
Well,
Like,
at
that
some
was
point he did say something with regard
just heard this
to
whole argument.
No,
That
I
was-
know, but at maybe a different part of these proceedings, he said that all they did is let him know that the protective order was retracted, that it wasn't in place anymore because
I mean, to be
this-
honest with you, I don't give a shit. What's this guy going to a military base for, cracking his SIM card and then destroying
Agreed.
the phone?
Agreed.
I mean, like why? It's this
Then changing his number and the carrier. Come on.
come on.
All right, good.
Because this is the end of it right here.
That it was in the Sallyport. There is an outdoor camera where you can see the car about to enter the Sallyport at 5:31. Of course, you can't see the tail light in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just ask the court to use common sense here that if the car is entering, and by the way, the car is there at 5:50 with a couple of people around it. When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sallyport. I believe that's the definition of motion, and it should have been picked up according to Mr. Lally's own words.
Yeah,
Okay,
mic
so
drop.
when you walk away
That's
from
the
it's hard to
definition.
order to hear you, Ms. Giannetti.
And I apologize, Judge. It's according to Mr. Lally's own words, it should have picked up the movement.
Okay.
You like apples? I got a number. How do you like them apples?
Let's see back here at 2. Mr. Lally, will you have Ms. Gilman, who I did see walk in here at one point, set
All
up
right,
the screen.
so that's that.
Where we normally keep it.
So I just think that that's a great primer for tomorrow. We got a lot of stuff about what we can expect the defense, Alan Jackson in particular, to be grilling Brian Higgins on. And Brian Higgins, an ATF guy, so I fully expect him to be pretty combative. I expect it to be a pretty good day in court tomorrow. Jackson at the end of court on Wednesday had said, the judge is like, I'm hoping that we can get this next witness, not naming who it was, that we can get him done in one day. And Jackson says, I'll do my best. I'm really hopeful to get him done in one day. That tells you there's a high likelihood that Higgins is going to be on the stand for the better part, if not the entire day tomorrow. So I am really, really looking forward to it tomorrow. And again, if y'all are new, please, on the way out, make sure that you like this video. It helps us grow the show. We're newer. We've been around 6 months. We're growing at a pretty nice pace. I think that we bring some pretty good content. Allie obviously knows her shit. If you're into badass women lawyers, that's your girl right there. She clearly brings it every single time we're on. And we'd love to have you guys. And if you like it, sub. We'd love to have you join the fam. We consider our community to be a family. We have a wonderful community that we built over the last so many months between the Shaming of Jay and myself and Publicly Buzzed and Joe Jackalone. Those are all super homies that we hang with. And We all love each other and promote each other.
Are you trying to rush off and not answer any of these super sticker
No, but I
questions?
just wanted to, I like, no way. Are you kidding? We had some incredibly generous shit going on today. I was throwing them up there. But if you guys have any questions, I kind of want to run through, and I want to give some shout outs to the people that were incredibly generous tonight with their money. And we are always extremely appreciative of this. But like I said, before we do that, make sure you like, share, subscribe. It really helps us out. And we hope that you'll check us out. We are streaming, like I said, we're streaming this trial every day. We know there's a ton of content creators out there streaming this thing. Basically everybody, all the big shows, all the little shows, all the shows in between are all streaming this trial because it's that trial. It's that trial. There was a 0% chance that I was not going to be covering this trial. And I was like in a state of panic because the other trial that I'm knee deep into is Delphi. Obviously, people that follow us know I'm the Delphi guy. I'm boots on the ground for that. And that trial was supposed to start on May 13th. So I had this horrible dilemma. I was going to have to put Allie to work. She was going to have to live stream it with Jay, but I got a reprieve because obviously they continued that trial until October. So I was incredibly pleased and happy that I got to do this trial because I just think it's an unbelievable case. There's just, it's got everything that you could ever ask for. Obviously, you know, we all have to remember John O'Keefe. And the one thing that's become evident to me during the course of this trial is that John O'Keefe was beloved by everyone that knew him. He was an incredibly stand-up guy. That was evident in the fact that there was no hesitation in him adopting his niece and nephew and raising them as his own. I've also come to the conclusion that every woman in Canton was in love with him. You know, he was that dude. Like, he was that guy. So it's an absolute tragedy what happened to him. And you know, when you use that hashtag justice for John O'Keefe, you should mean it because he was worth it. We need to get to the truth here. And sometimes the truth hurts. Sometimes the truth is much, much stranger than fiction, you know, and there's people out here that are like, oh man, this conspiracy thing is crazy. Well, it is, and it isn't. You know, it's like, I don't think that it has to be a vast conspiracy. I don't know. Like I said at the beginning, I am firmly sitting right here on the fence. I have my personal thoughts about what I think may have happened, but I am waiting until every single piece of evidence is presented and vetted. And at that point, I will come to my conclusion. And I urge all of you to do the exact same thing because you can't know until you know, So, but enough of the soapbox. DSN $5 hollow. Appreciate you so much. Haven't seen you before. Welcome. We hope that you hang around. Come back. Pam, you know, I love you, girl. Thank you so much for that $10 hollow. We'll see you tomorrow. I know that. Kasha, wow, dude. Yes. You'll know, I will definitely see you at CrimeCon. 100%. Allie, we'll be there. Make sure that we're hanging. Make sure you come by our table. I think they gave us the setup. We're right across from the big court TV setup. So I got Music City right by me, 911, a bunch of great pods right by me. And I'm going to be right next to Vinny. Vinny and I are pretty tight. So I like that they stuck me over there by Court TV. And I'm on Court TV quite a bit. So that made sense. Thank you for that incredibly generous $100 hollow. That's unbelievable. Always Giver Dawn Burke, another incredible, generous gift. Thank you so much, Dawn. We adore you. Nav the EO, always coming in hot with 50 DD podcast memberships. I'm sure that the people who are lucky enough to get that membership are thankful as well. Thank you for your continued support. It means the world to us. Angie Sherman, thank you for that $5 hollow. It means the world. Jen Del Rio, hope you come back. Like, I've seen you a couple times, I think. If you're new, make sure you come back. And I appreciate that $10 hollow. Lady Di 2 gifted 10 memberships for DD. Appreciate that. Spreads the love, builds a family. Aw, family hug. So thank you so much for that. We really appreciate it. OG Alpha Shiwa, 4-month member. Amazing. We appreciate that. Jamie Nichols, $2 holla. I'm a Sagittarius. I've looked it up. Like everything that I ever read about Sagittarius, it's pretty spot on. So thank you for that $2 holla. Appreciate it. Steve Trammell, $2 holla. Would be hilarious if Lally was working for the feds. That would be hilarious. Don't hold your breath on that one. But I mean, who knows? You know, like in this world, I don't put anything past anybody, to be honest with you. It's like there's too much crazy shit that goes on. It's like in Chicago, it's like people are like, it's hard for people to wrap their minds and come to grips with the fact that there are amazing cops out there who put their lives on the line and really make our society a better place. And then there's cops that are shitbags. That's just facts. Like any profession, you have great and terrible in every single profession known to mankind, and cops are no different. The difference between a cop is that they have a huge amount of power. That gun and that badge gives them a frightening amount of power. And when they abuse it, it can have absolutely devastating effects on other people's lives. And that's what defense attorneys do. We police the police. Like when you hear these motions, and I'm not going to go into my diatribe because our people have heard me say it ad nauseum, but when we file a motion to suppress alleging that a cop has violated somebody's constitutional rights, we're not doing it for that individual alone. We're doing it for all of us, because if we don't file those motions, those cops that are violating the law, our rights, they will continue to do it if they don't get smacked in the face and told, hey, you know what? That evidence that you got pursuant to an illegal search has now been deemed inadmissible. We're tossing it as fruit of the poisonous tree. That case is gone. The hope is that that cop learns from that, and the next time they're presented with that issue or that particular type of situation, they're going to follow the law. It's that simple. If we don't do it, and we're defense attorneys, the only ones who can do it. We're the only ones on the planet who can protect our rights. It sure the fuck isn't the cops, and it sure the fuck isn't the prosecution. Get that straight. Just understand that about what defense attorneys do.
So let me
All right.
answer Kat Toe's question.
Yep.
I really hope Bob or Allie can answer whether the FBI proffer protects Higgins in FBI and the state cases. So no, unless it was something that they went into jointly or some other special situation, the state is not bound by the agreement of the feds in their proffer letter. Moreover, at the time at that time, he was being investigated for presumably, like corruption, not necessarily the murder of Karen Reed. Even though technically they go hand in hand, it's not the same offense. And I think what he would have to do in the state case, like let's say the proffer involved more, which I think we know from the hearing we just watched, it doesn't, or he would have spoke to that stuff. So the proffer involved him destroying his phone, and depending on which side version you want to accept, that possibly state actors told him that he was free to do that, and sort of given the okay or the direction to do that. He would have to plead the fifth on the stand. And again, I don't think he's going to do that. I'm just saying, if you want to protect yourself from the things that you put into a proffer letter, you have to, plead the fifth.
Yep. All right. So hopefully Cat Toes that gives you the straight dope. So, all right. I think that's it. I hope you guys found it to be informative. Like what the hope was is that we're all going to go into this thing with just a little bit more understanding of what to expect tomorrow, kind of having a better idea of what the defense is hoping to bring out during that cross-examination of Brian Higgins, which should be explosive. If we're to believe Alan Jackson is in his statement to expect fireworks tomorrow, which I have no reason to doubt him. I thought that the cross of Jen McCabe was absolutely epic in so many ways. I thought it was unbelievable. So I'm really looking forward tomorrow. We will be live streaming, started at 7:45 on our channel where you're at right now. And next week, as you guys know, very short court schedule. They're only, obviously, Monday's Memorial Day. Happy Memorial Day if I don't see you all tomorrow on Monday. But only Tuesday next week. And then the judges, there's no court the rest of the week. So we only have one day of court next week. And that will be, I believe, on Jay's channel. So we'd love to see you guys tomorrow if you're new. If not, enjoy yourselves. Enjoy the trial. Check back. Remember, on the way out, please, please, please like, share, subscribe. Because without you guys, you know what? I always say it, babe. I just be an old man.
Talking about a lot of cases.
Ooh, girl, you ain't never lied. We will talk to y'all later.